Nasa huling parte na tayo ng ating subject matter. We are now on defective contracts. Mga kontrata na defective. May problema sa mga kontratang ito. Bilang pundasyon, as a backgrounder, sa batas natin, hindi lang valid at void ang mga kontrata. Sa pagitan ng valid, sa pagiging valid, perfectly valid, at sa pagiging void or inexistent ng isang contract, may mga nasa pagitan niya. So, para siyang spectrum. Para siyang para siyang spectrum. Valid, and then unti-unti nagiging void. Meron siyang in-between. So, yung mga in-between na yan, including the void contract, is what we refer to as defective contracts. So, ito yung mga defective contracts. We have rescissible contracts, voidable contracts, unenforceable contracts, and void. Yung pagkaka-arrange niyan, rescissible, voidable, unenforceable, and void, ay according to their efficacy. Ibig sabihin sa least defective to the most defective, to the pinakamaayos hanggang sa pinakawalang kwenta. So from rescissible, pababa, voidable, and then unenforceable, and then void. Okay? So, tandaan niyo ang rescissible, tawag dito, itong apat na ito, bubulolin na ako. Itong apat na ito ay natin, i-overview natin. Siyempre, merong detailed discussion on each and every item, pero sa ngayon pa lang, para meron na tayong working knowledge dyan sa apat na yan, i-overview natin sila. Okay, unahin natin yung rescissible. Yung rescissible contract, siya, valid contract siya, kaya lang merong damage or prejudice to a third person. So, tatawagin natin ngayon yung tatlong elements ng contract. You have the consent, object or subject matter, cause or consideration. Sa rescissible contract, present yan lahat at walang problema. Wala tayong problema sa consent, object or subject matter, cause or consideration. Nagkataon lang na although present yung tatlo na yan, merong third party, actually, merong party or third party na nag-suffer ng damage. So, merong damage incurred to a third party. So, kaya siya naging defective. Okay sana yung kontrata ninyo, kaya lang may naagrabyado. May naagrabyado din sa kontrata na yan. So, meron tayong right, yung third party na may right to ask for its rescission. Okay? So, perfect lahat ng elements of the contract. Just so happen na merong pecuniary damage na kailangang i-address. Voidable contracts. Ito, hindi naman the first time na mapapag-usapan natin yung voidable. Sa voidable contracts, andyan yung consent, andyan yung object, subject matter, andyan yung cause and consideration. Nagkataon lang na yung consent ay defective. Nagkataon lang na yung consent ay vitiated. For what reasons? It's either yung nagbigay ng consent ay incapacitated to give the consent, or yung pagbibigay niya ng consent, even if capacitated siya, ay vitiated. No? Present yung VIMPO. Napag-usapan na natin yung VIMPO before. Violence, intimidation, mistake, fraud, undue influence. Or it's also possible na siya ay under a hypnotic spell. We have talked about that. Or in state of drunkenness. Yan. Kung mapapansin nyo, isa lang naman yung kwento dyan sa mga provision na yan ng batas. Nagbigay siya ng consent pero hindi niya lubusang naintindihan o hindi malaya yung pagkakabigay niya ng kanyang consent because of those factors na binanggit natin. Okay? Ang unenforceable naman, ganun uli, merong consent, object, consideration. Kaya lang, under the law, meron siyang tatlong problema. Yung unang problema ay authority. Merong problema doon sa authority. Ibig sabihin, there are contracts na either unauthorized or even if authorized ay nag-exceed siya sa kanyang authority. That's number one. Number one reason why a contract may be declared as unenforceable. Pangalawa ay yung tinatawag na statute of frauds. Statute of frauds. Frauds panloloko, sir? No, not really. No? Pero may kinalaman doon. Pero hindi ito yung fraud na incidental fraud or causal fraud. Ang tawag sa kanya statute of frauds. May mga kontrata na nire-require yung batas na isulat para maging enforceable. We have talked about this before. I think in the last video about form of contracts. Diba, sabi natin, contracts are valid in whatever form they may have been entered into, except if the law requires that the contract must be in a certain form for it to be either for it to be valid or for it to be enforceable. Yung portion that for it to be valid, yan, napag-usapan natin yun doon sa last video. Yung for it to be enforceable, ito siya. Yan. Yung provisions ng yung provision ng civil code which requires or mandates certain contracts to be in writing for it to be enforceable ay na makikita mo dito sa provision na covering unenforceable contracts. Again, we refer to it as statute of frauds. And then, number 3 both are incapacitated. Para silang incapacitated to enter into the contract. Oh, so ibig sabihin kung isa lang yung incapacitated, voidable siya. One incapacitated, one capacitated, voidable. But if both parties are incapacitated to enter into the contract, then unenforceable siya. So in effect, magkakaroon ka rin ng problema with the consent pagdating dito sa number 3. Kasi parehas kayong incapacitated to enter into the contract. And then finally, void. Again, this is not the first time that we will be hearing about void contracts. Paulit-ulit ko nang binanggit to before. In a void contract, one, some, or all of the essential elements, meaning consent, object consideration, or object or subject matter, cause or consideration, ay nawawala, ay missing or lacking, or illegal. Which, in effect, kapag illegal siya, as if wala din siya. Diba? So, walang consent, walang object, o walang consideration, void yun. Kulang ng isa, kulang ng dalawa, o kulang lahat, will render the contract void or inexistent. Okay? O kaya, meron man, may consent, may object, may consideration, kaya lang yung object ay illegal. So again, anong effect kapag ang isang object ay illegal? It does not exist. By contemplation of law, hindi siya considered as a valid object. At dahil siya ay hindi considered as an object, kulang ka ngayon ng element. Meron, pero because of its illegality or being unlawful, then as if wala siya. Void pa rin yung kontrata. So ganun yung overview natin with respect to defective contracts. Now we go into the details. Rescissible contracts. Article 1380 defines rescissible contracts as contracts validly agreed upon, which may be rescinded in cases established by law. Although hindi nga binanggit sa 1380 yung mga cases established by law. Pero ang pinaka-importante sa Article 1380 is the declaration by the law itself that rescissible contracts are valid contracts. These are contracts validly agreed upon. So wala kang problema, di ba? Binanggit na nga natin dito sa comparison natin na wala kang problema pagdating sa consent, object, subject matter, cause, or consideration. They are entered into and they are entered into validly. Kaya nga minsan ang tawag sa rescissible contracts are valid contracts until rescinded. Rescissible contracts are valid contracts until rescinded, until you ask the court, one of the parties ask the court to have it rescinded. But prior to its rescission, rescissible contracts are considered as valid contracts by express declaration of Article 1380. Contracts validly agreed upon may be rescinded in the case established by law. Okay? So, tapos na tayo dyan. Ito na, in-enumerate niya ngayon yung under Article 1381, yung mga rescissible contracts. Okay, number 1, those which are entered into by the guardians whenever the wards whom they represent suffer lesion by more than 1/4 of the value of the things which are the object thereof. So this is not the first time that we will be hearing about lesion. When we say lesion, there is inadequacy of consideration. We discussed about this term nung tayo ay nag-aaral ng cause or consideration. Ang sabi natin doon, way back nung pinag-aaralan natin yon, lesion or inadequacy of the consideration will not affect the validity of the contract. Kahit gaano pa kababa, kahit gaano pa kaliit yung consideration, okay lang yun. Diba kung ikaw yung party, kung gusto mong ibenta ang kotse mo worth 1 million ng piso lang, then so be it. Kung gusto mong piso lang. Kasi nga, sabi nga ng batas, kung pwede mo nga yung i-donate, ba't ka namin pagbabawalan na ibenta siya below the fair market value? So again, as a general rule, lesion or inadequacy of the consideration will not affect the validity of the contract. Unless, sabi nga ng provision na yun, I just don't recall the number of sabi ng provision na yun, unless the lesion is caused by fraud, mistake, undue influence, etc., etc. In which case, actually, it's not the lesion na magiging problema mo doon, but the reason bakit nagkaroon ng lesion, not the lesion itself. Pero bakit dito naging rescissible siya? Tandaan nyo dito, merong sa number 1, may guardian, may ward. Pag ikaw yung guardian, you are authorized to manage the properties of your ward. Yun yung relationship eh. Ikaw yung guardian, and then ito yung ward. So that's the ward. So you manage the properties of the ward. So the guardian entered into a contract with another person. So you have this person. So the contract is between them, but the subject matter of the contract belongs to the ward. So G enters into a contract with X with respect to the properties of the ward. So yung ward, if the ward will suffer lesion by more than 1/4, so merong measurement by more than 1/4, then it is rescissible on the part of the ward. So si ward, sa parte ni ward, dahil siya yung biktima dito, siya yung naagrabyado dito. Di ba sabi ko sa inyo, ang mga rescissible contracts ay valid contracts pero may ibang taong naagrabyado. So dito ang naagrabyado dito si W. Si W naagrabyado kasi nagsuffer siya ng lesion by more than 1/4. So kung si W ay nagsuffer ng lesion pero hindi naman more than 1/4 ang nasuffer niya na lesion, it is not even rescissible. It's not rescissible. So dapat yung damage, yung pecuniary damage or the disadvantage on the part of W ay dapat lumagpas ng more than hindi sakto. It should be more than 1/4 of the value of the thing, subject of the contract. Number 2 is the same. Those agreed upon in representation of absentees. If the latter suffers lesion stated in the preceding number. So sa number 2, ang meron naman dyan ay representative tapos absentee. Si absentee ay, as the term would imply, nawawala. Wala siya. Is not present. So meron siyang representative. Si representative ay merong pinasok na contract with another party. Let's say si X ulit. So the contract is between R and X, but the subject matter of the contract is a property or thing belonging to A, the absentee. So insofar as A is concerned, the contract between R and X will be rescissible if A will suffer lesion of more than 1/4. Okay, that's number 2. A can ask for the rescission if the lesion is more than 1/4. Hindi automatic yung lesion dahil lang nalugi siya dun sa transaction, pwede niya nang ipa-rescind yung contract. Hindi. You have to measure. You have to compute magkano ba yung lesion or ano ba yung ratio o ano ba yung fraction ng lesion na nasuffer nitong guardian na ng ward na ito or ng absentee na ito. Okay? Number 3, those undertaken in fraud of creditors when the latter cannot in any manner collect the claims due them. This is not the first time that we will be hearing number 3. Diba? From the very beginning, matagal na natin pinag-uusapan yung tinatawag nating action Pollyanna. So action Pollyanna is the right of the person to rescind or ask for the cancellation of a contract if that contract is entered into to defraud them. So right granted to creditor. So ako yung creditor, yung debtor ko ang ginawa, dinonate niya yung mga properties niya para hindi ko mahabol as a creditor. Diba? As a creditor, you have the right to run after the properties of your debtors if they are not able to pay. So si debtor, sabi niya, alam ko yung batas na yun. Uunahan ko tong creditor na to. So para hindi niya mahabol yung aking mga properties, i-donate ko na lang sila. Donate-donatan for example. Dinonate niya na. So that the donation of the property without the person reserving sufficient assets to pay for his or her obligations is presumed to be fraudulent. So, kapag meron kang utang tapos dinonate mo yung properties mo to the point na hindi ka nag-iwan ng sapat na properties pambayad ng mga utang mo, yung donations ay deemed to be made in fraud of or undertaken in fraud of creditors. So the creditors, since the contract, again, ganun uli, merong naagrabyado dito, yung creditors. Yung creditors ay naagrabyado dito, they can ask for the cancellation of the contract or of the donation because that donation was entered into to defraud them. Number 4, those things which refer to things under litigation if they have been entered into by the defendant without the knowledge and approval of the litigants or of a competent judicial authority. So may property which is in the jurisdiction or in the control of the court. Ang tawag dito ay properties in custodia legis. Custodia legis. In custodia legis. So if the property is in custodia legis, ang literal translation niyan ay in custody of the court. The property is in the custody of the court because it is the subject matter of the litigation. Pinag-aawayan siya. So kung yung kotse ay pinag-aawayan sa korte, yung kotse na yan ay considered as in custodia legis. Kung ang isang bahay at lupa ay pinag-aagawan, yan, yung property na yan, at may naka-file na kaso sa court involving that property is in custodia legis. So kung ikaw yung defendant and who is in the possession of that property, tapos binenta mo siya without informing the other parties or even the court, that is a rescissible contract. Bakit? Siyempre maagrabyado yung plaintiff. Bakit maagrabyado yung nagkaso sa'yo? Pag sinabing plaintiff, nagkaso. Defendant yung kinasuhan. So bakit? Ba't siya magiging maagrabyado? Siyempre, what if manalo ako? Kunyari ako yung plaintiff, kinasuhan kita. Nanalo ako, sabi ng court, o sige, bigay mo na yung napag-desisyonan na yan ay para sa plaintiff, yung property na yan. Ano mapapala ako? Ano na lang mahabol ko kung dinispose mo na yung property? So if the property is under the custody of the law or of the court, it is in custodial legis, it is under litigation, the defendant should not dispose of the property. Or if he or she would decide to dispose of the property, he or she should inform the plaintiff, the parties, and even the court. And number 5, all other contracts specifically or specially declared by law to be subject of rescission. So yung example niyan will be the next item. So if you will observe 1, 2, 3, and 4, walang problema with the consent, object, and consideration. Nagkataon lang na merong ibang tao na naagrabyado kasi pumasok ka dun sa kontrata. That by express declaration of Article 1381, these contracts are considered rescissible on the part of that third person. Sabi dito, all other contracts specially declared by law to be subject to rescission, just like Article 1382, payments made in state of insolvency for obligations to whose fulfillment the debtor could not be compelled at any time they were affected are also rescissible. So, ibig sabihin, sa provision na ito ng batas, yung debtor ay insolvent na. So insolvent na siya, ibig sabihin hindi na sapat yung kanyang properties para yung kanyang assets para bayaran ang lahat ng kanyang liabilities. Yun yung status ng isang insolvent na person. So kung ikaw ay insolvent, para hindi naman maagrabyado yung ibang, kunyari meron kang 10 creditors. For example, si X ay merong 10 creditors. 1, 2, 3, 4, etc. hanggang kay 10. Yan yung mga creditors niya. Insolvent na siya. So, ibig sabihin, yung properties na hindi sapat para bayaran tong mga to. 1 to 10. Creditor 1 to creditor 10. It would be unfair if X will just pay 1, creditor 1, or just creditor 2 and 3 without paying 1 to 10, or just pay 10. Ganon, hindi pwede. So, para hindi maagrabyado yung iba, yung magkakaroon ng distribution ng assets niya. Siyempre, dapat mag-claim tong mga to, creditors 1 to 10. So in the meantime, na hindi pa na-determine lahat ng kanyang utang at kung paano siya babayaran, si X ay bawal munang magbayad ng mga utang niya. Hindi siya pwede magbayad ng mga utang niya. Kasi nga, i-determine na paano niya babayaran lahat ng kanyang pagkakautang. Share ba sila? Meron bang preferred dyan? Uunahin yung government? Uunahin yung mga empleyado? Meron bang exempt dyan na hindi pwedeng habulin na properties ni X? Etc. Hanggat di pa nasa-settle yung mga issues na yan, X is prohibited from making payments. And payments made in state of insolvency for obligations to whose fulfillment the debtor could not be compelled at the time they were affected are also rescissible. Okay? Rescissible yan. Kung insolvency X at nagbayad siya, rescissible yung contract, yung payment na yun. Okay. 1383, the action for rescission is subsidiary. It cannot be instituted except when the party suffering damage has no other legal means to obtain reparation for the same. Diniscuss ko na to way early. No? Nasa obligations pa lang tayo na pag-usapan na natin to. Sabi ko sa inyo, ang rescission ay remedy of last resort. Kung meron kang ibang kayang gawin, yun ang gawin mo. Huwag mong ipa-rescind kasi nga ang rescissible contracts ay wala namang problema sa kanila. Nagkataon lang na naagrabyado ka doon sa kontrata. So kung may ibang paraan para ikaw ay makabawi, yun ang gawin mo. Kung walang-wala na talaga, saka ka pwede mag-file ng action in court to ask for the rescission of that contract. And the court will inquire. Sabihin ng judge, Mr. X, you're asking for the rescission of this contract between A and B. Ayan. But prior to doing this, no, ano ba ang iba mong ginawa? Bago ka nag-file ng action o ng complaint for the rescission of the contract, may we know ano ba ang mga iba mong pinagagawa bago ka nag-decide na mag-ask for rescission? Naghabol ka ba sa ibang tao? Trinay mo bang makakolekta from the debtor? Trinay mo bang hanapin yung mga properties niya? Trinay mo bang mag-avail ng ibang remedy bago ka nag-rescission? Kung totoong ginawa mo yan, nasaan ang patunay? Tatanungin ng court yan. And if you fail to convince the court that you availed of other remedies, then your complaint for rescission will not prosper. I-dismiss lang ng korte yan. Okay? Yan siya. So, it's a remedy of last resort. Pero kung wala ka na talaga, patunayan mo sa korte, trinay ko na po lahat. Hinabol ko siya, hinabol ko yung mga creditors niya, ay mga debtors niya. Ginawa ko po lahat. Naghanap ako ng properties niya, pero wala po talaga. Yan na po talaga ang pwede kong gawin. Then, so be it, sabihin ng korte. Let us proceed. 1384. Rescission shall be only to the extent necessary to cover the damages caused. So again, dahil nga ang rescissible contracts ay mga valid contracts, pwede na yung kontrata ay iparesin partially. So wag mong iparesin ng buo. So for example, si X at saka para maintindihan, si debtor ay may utang kay creditor. Ang utang niya ay 1 million. At that time, si debtor ay merong properties na 3 million. Ang ginawa niya, dinonate niya lahat kay X. Donate. So, nang sabi natin, if a person donates all of his properties without leaving sufficient properties to settle his or her obligations, the donation is deemed to be entered into in fraud of creditors. So, sisi ngayon, ang creditor dito, this donation was made to defraud C. So, kung wala nang ibang remedyo si C, anong pwede niyang gawin? Ask for the rescission. Pwede niya bang iparesin ng buo yung 3 million? Hindi. Although si C may ask for the rescission of the donation, bid of donation between D and X, C can only ask for the rescission up to the extent of 1 million only. Kasi yun lang naman yung kailangan niya. Kasi yun lang naman yung claim ni C. So, ba't mo ipaparesin ng buo yung 3 million? Yung buong 3 million ba yung claim mo, C? Hindi po. Magkano lang ba yung claim mo? 1 million. O hanggang 1 million lang din ang pwede mong iparescind. Okay? Yun yung point ng Article 1384. 1385. Rescission creates the obligation to return the things which were the object of the contract, together with their fruits, and the price with interest. Consequently, it can be carried out only when he who demands rescission can return whatever he may be obliged to restore. So kapag nagkaroon daw ng rescission, hanggang dito muna tayo, kapag nagkaroon daw ng rescission, kailangan magbalikan. Na? Magkakaroon ng mutual restitution ang tawag dito. Kung ano man yung mga natanggap ninyo sa kontrata na yan, ay kailangan nyong ibalik sa isa't isa. Mutual restitution. Magkakabalikan kayo. Wow. Gusto nyo yun? Magkakabalikan kayo ng mga natanggap ninyo mula dun sa kontrata na pinaparescind na nga. So kung ibig sabihin kung hindi mo kaya na ibalik yung mga natanggap mo before, you cannot ask for rescission. Kasi kapag grant ng court, sige, gagrant ko yung complaint mo for rescission. Balik mo na yung mga nakuha mo sa card. Pag hindi mo kaya, wala. Okay. It can be carried out only when he who demands rescission can return whatever he may be obliged to restore. Pero kung wala naman siyang natanggap mula sa kontrata na yan, then pwede siya magpa-rescind. Kasi wala naman siyang ibabalik eh. Diba? Wala siyang ibabalik. So, okay lang. But if both parties have reached or received something from that contract, then you can only ask for a rescission if you are able to return whatever you received from the contract. Neither shall rescission take place when the things which are the object of the contract are legally in the possession of third persons who did not act in bad faith. Ibig sabihin, they are in good faith. So going back to the example dito, di ba, si D, may utang kay C na 1 million. Si D, ang properties lang 3 million. Properties niya 3 million. Dinonate niya lahat kay X without leaving behind sufficient properties to pay for his or her obligation. Yung property na dinonate kay X ay binenta kay Y. Y does not know anything about these issues. Wala siyang kaalam-alam dyan sa mga nangyayari. Ang alam lang niya, meron siyang property na binili mula kay X. That's it. Hindi niya kilala si D, hindi niya kilala si C, hindi niya alam na may utang at may dinonate, etc. etc. So, ibig sabihin, Y is innocent. Diba? It pays to be innocent talaga minsan under the law. Hindi alam ni Y, wala siyang kaalam-alam sa mga nangyayari o mga naganap sa pagitan ng mga naunang partido. So Y did not act in good faith. Did not act in bad faith, meaning good faith siya. Y is in good faith. So pwede pa bang ipa-rescind ni siyan? Sagot dito, neither shall rescission take place when the things which are the object of the contract are legally in the possession of a third person who did not act in bad faith. So in our problem, Y did not act in bad faith. So C can no longer ask for rescission because yun nga, the property subject matter of the rescission is now in the hands, ownership or possession of a third person who did not act in bad faith. If Y is in bad faith, then okay, C can still ask for the rescission. Meaning, Y knows, alam niya na merong problema, may sigalot, merong controversy, may issue between D, C, and X. May issue dyan. Aware si Y na may utang si D kay C. Aware si Y na ang properties na lang ni D ay 3 million. Aware si Y na kahit na may utang siyang 1 million kay C, dinonate lahat ni D kay X yung properties na hindi siya nag-iwan ng kahit 5 duling para may maipambayad kay C. So kung aware si Y doon, alam ni Y na merong defect or merong questionable. Alam ni Y na questionable yung property kasi pinagpasapasahan ng hindi nagko-comply sa batas. So ano ngayon? Kung si Y aware, despite the knowledge of Y, with respect to the defect, binili pa rin niya. So although the subject matter of the contract is in the possession of Y, a third person, Y acted in bad faith. If Y acted in bad faith, C can still ask for the rescission. Okay? In this case, indemnity for damages may be demanded from the person causing the loss. So kung sabi nga dito, kung ang property ay nasa kamay na ng third person who did not act in bad faith, then the remedy, kasi hindi na maparisin din na sa ibang tao na, will be converted to a recovery of monetary damages. Okay? Indemnity for damages na yung magiging solusyon. 1386 rescissions referred to in numbers 1 and 2 of Articles 1381 shall not take place with respect to contracts approved by the court. So 1381, 1 and 2. So dito, 1381, 1 and 2 with respect to the wards and with respect to absentees. Maaari na si G, si guardian, at si R, si representative, ay pumunta muna sa korte bago nagbenta. Nag-seek sila ng prior approval from the court before they decided to enter into the contract involving the property of W and A. So even if W, the ward, or A, the absentee, will suffer lesion of more than 1/4, it is not rescissible if they obtain prior approval from the court. Kasi yung court mismo nagsabi, sige, okay na yan. Benta mo na yung properties ng ward. Okay na yan, yung contract involving the property of the absentee. Kung considered pa rin yan as rescissible, pupunta ka na naman sa court. Sa court, yung court ka nag-approve ng kontrata, di ba? Iikot ka ng kwento, yung court na yung punot dulo dito. So if approved by the court, even if the ward or the absentee will suffer lesion of more than 1/4, it is not considered as rescissible. 1387, all contracts by virtue of which the debtor alienates property by gratuitous title, ibig sabihin by donation, gratuitous title yan, nagdidispose siya ng walang kapalit, are presumed to be or to have been entered in fraud of creditors when the debtor did not reserve sufficient property to pay for all his debt. So sabi ko nga sa inyo, yun yung sitwasyon. Kapag ikaw ay debtor, hindi pwedeng i-dispose mo lahat ng properties mo gratuitously. Pero pag onerous, binenta mo, then okay lang yun. It cannot be presumed to be entered into in fraud of creditors. Ang in fraud of creditors ay yung mga gratuitous disposition. Di pinagdodonate niya yung mga properties niya, alam niyang marami siyang utang. Di ba? Tama lang naman. Dami mong utang tapos namimigay ka. Kung bayaran mo kaya yung utang mo, wala namang masama sa pamimigay, di ba? We encourage generosity, di ba? Or charity. We encourage charity and generosity. Pero bago mo gawin yan, bayaran mo muna yung mga utang mo. Kasi anong gagawin ng mga pinagkakautangan mo kapag nawalan ka na ng property? Wala na silang makahabol. Yun lang naman yung point. Hindi man niya sinasabi huwag kang mag-donate. Huwag kang mag-donate kung may mga utang kang hindi mo na mababayaran after mo mag-donate. Huwag mong gagawin yun. Okay? Second paragraph, alienations by onerous title are also presumed fraudulent when made by persons against whom some judgment has been rendered in any instance or some writ of attachment has been issued. The decision or the attachment need not refer to the property alienated and need not have been obtained by the party seeking the rescission. So dito naman, pag alienation, ibig sabihin dinispose niya yung property niya. Transfer niya yung property. Hindi alienation na nagiging alien siya out of this world. Hindi ganon. Alienation meaning transfer or disposition of property by onerous title. Ito naman may kapalit. Pag gratuitous title, walang kapalit. Pag onerous title, meron. Ang sabi natin, pag onerous, hindi siya presumed fraudulent. Pero ang sabi nito, it is presumed fraudulent kung meron judgment render against you. Ibig sabihin, may kaso ka dati, tapos yung kaso na yun, napag-desisyonan na. At sabi dun sa desisyon na yun, kailangan mo magbayad. May kailangan kang bayaran. Inuutusan ka ng korte, o Mr. X, magbayad ka, gantong amount kay Mr. Y. So, a judgment has been rendered against you. Okay? Tapos dinispose mo yung property mo, inalienate mo yung property mo. Even if by onerous title yan, it is still presumed to be fraudulent. Kasi nga, meron ng kaso o may decision na ng kaso laban sa'yo. Or kung meron kang writ of attachment. Pag sinabing writ of attachment, paano ba explain sa inyo to? Pag sinabing writ of attachment, ito ay isang provisional remedy. Ibig sabihin, nagsimula pa lang yung kaso, humihingi ka na ng saklolo sa korte. Kunyari, kinasuhan ni X si Y. Utang. Sabi ni X kay Y, magbabayad ka ng utang mo, ayaw magbayad. So si X ay napilitan dahil sa refusal ni Y na magbayad ng kanyang utang. Si X ay napilitan na maghabla. Nalaman ni Y. Ay, pinasuhan ako ni X. At kapag ako ay napatunayan na may kailangang bayaran, hahabulin ni X yung mga properties ko. So, ang ginawa ni Y, nag-post siya sa Facebook sa marketplace. Hindi niya ang intention na ibenta. Hindi niya pa nabebenta. Pero yun na yung papunta na siya doon, patungo na siya doon sa pagbebenta. Nag-post na siya. Nabasa ngayon ni X, ginagawa ni Y, ikinasuhan ko siya. So ang gagawin ni X, pwede siyang pumunta sa court, hindi pa simula pa lang ng kaso, at pwede siyang manghingi ng tinatawag ng writ of attachment. Writ of attachment. Sasabihin ni X sa court, judge, di ba kinasuhan ko si Y? Nag-file ako ng complaint dito sa korte ninyo. Nalaman ko po na si Y fraudulently tinatransfer niya mga properties niya. Or may plano siya na i-transfer yung mga properties niya. Ganun ba? Oo. At ang problema ko po, Judge, kung sakaling mananalo ako dito, magiging walang kwenta yung panalo ko. Kasi wala na yung properties niya, dinispose niya. Ganun ba? Sabihin ng court, sige. Because of that, na-convince mo ko na mag-i-issue ako ng writ of attachment. So, pag sinabing writ of attachment, pinapaalalahanan o pinapagbabawalan itong party na i-dispose yung property. Kasi naka-attach na siya. Yan. May rate of attachment. Yung mga buyers naman, medyo ano din sila dyan, iwas din sila dyan. Kapag isang property ay may rate of attachment yung property, makikita nila yun eh. Palagay sa sa titulo ng property, ay, naka-attach tong property na ito. Ibig sabihin, may kaso involving this property, or may kaso, although the property is not the subject matter of the case, naka-attach to kasi siguro yung defendant may ginawang kakaiba. No, pinakita niya sa court na hindi siya mapagkatiwalaan na tatakbuhan niya yung kanyang kaso. Kaya, inattach yung property. Delikado yan, no? Na magbibili ka ng mga properties which are attached. Kaya, di ba, kadalasan kapag ikaw ay interested in buying properties, you require that the title to that property is clean title. Eh, kapag may attachment yan, hindi yan clean. Alam mo may attachment, tapos binili mo. O if later on, sabihin ng korte, bigay yan dun sa naghabla, mawawalan ka. At hindi mo pwedeng sabihin, hindi ko yan alam. Hindi mo pwedeng hindi alam. Kasi ang rate of attachment, nakatatak yan. Naka-annotate yan sa titulo ng lupa o title to the property. Okay? In addition to these presumptions, the design to defraud creditors may be proved in any manner recognized by the law or rule on evidence. So bukod daw dito, pwede mo pang patunayan ang fraud sa ibang paraan. Bahala ka. Basta kung ikaw ang nagsasabi na merong fraud, ikaw ang merong obligasyon o burden na yan ay patunayan. He who alleges has the burden to prove such allegation. Kung ikaw ang nagsabi, ginawa niya yan para makapanloko. Fraudulent yan. Patunayan mo. Ay, peke yan. Patunayan mo. Ay, ganito yan. Ikaw magpatunay. Kung ikaw may sinasabi, ikaw ang merong obligasyon na patunayan yan. Okay? 1388. Whoever acquires in bad faith the things alienated in fraud of creditors shall indemnify the latter for damages suffered by them on account of the alienation whenever due to any cause it should be impossible for him to return them. So, di ba sabi natin kanina, kapag yung property ay nasa kamay na ng third person who did not act in bad faith, hindi mo na pwedeng rescind. Ikaw na inutusan na tawag dito, ikaw na itusan. Ikaw na third person who is in bad faith, alam mo na yung transfer sa'yo ay in fraud of creditors, you will also be liable for damages. Siyempre, di ba parang nakipag-conspire ka eh. Gusto mo bang matulungan yung sarili? Tulungan kita. Transfer mo sa akin yung property. In fraud of creditors yan. You acquire the property in bad faith. So you will also be liable for damages. Especially if you have transferred the property to a third person para hindi na mahabol. Sabi, sige, donate mo sa akin tapos ibibigay ko sa iba. I-dispose ko in favor of another person na hindi naman nakakaalam. So siya good faith, ako bad faith. So pag nasa kanya na, hindi niya mahahabol, mali ka dyan. Ikaw ang mananagot. Although hindi niya nga mahahabol kasi in good faith yun, ikaw will be liable for damages in accordance with Article 1388 of the Civil Code. If there are two or more alienations, the first acquirer shall be liable first and then so on successively. So kung pinagpasapasahan ng marami yan, tapos lahat kayo in bad faith, uunahin yung nauna, and then pag iwala, pangalawa, pangatlo, pang-apat, hanggang sa mahabol yung property. Okay? That's 1388. 1389, the action to claim rescission must be commenced within 4 years. So, ito, ang tawag dito ay prescription. It's not the first time that we will hear the word. Pag sinabi natin prescription, by the passage of time, ikaw nakaka-acquire ka ng rights. By the passage of time, ikaw ay nawawalan ng rights. So dito meron kang karapatan to ask for the rescission. Okay. Sabi, yung karapatan mo to ask for the rescission of the property, of the contract, not the property, ay dapat mong dalhin sa korte within a period of 4 years. Sa 4 na taon ang prescriptive period. ng right mo to ask for the rescission under Article 1389 or pursuant to Article 1389 of the Civil Code. Saan ko po bibilangin yung 4-year period na yan? For persons under guardianship or for the absentee, the period of 4 years shall not begin until the termination of the former's incapacity or until the domicile of the latter is known. Ibig sabihin, kung ang problema ay yun nasa number 1 and number 2, with respect to guardians, with the properties of the ward, and the representatives with respect to the properties of the absentee, kapag nawala na yung incapacity ng guardian. So for example, si X, si guardian, si G, at saka si ward. Si ward at that time ay 2 years old. So ang ginawa ni G ay binenta niya kay X yung property ni W with G suffering lesion of more than 1/4. So insofar as W is concerned, not G pala yung nag-suffer ng lesion, W. Insofar as W is concerned, the contract entered into between G and X ay rescissible. Pero kailan gagawin ni W yung pagpunta sa korte para hingin ang rescission nung nung kontrata na yan? Maghihintay siya na mag-reach ng age 18 years old, and then once na maging 18 years old siya, meron siyang 4 na taon, 19, 20, 21, 22, para magpunta sa korte at mag-file ng action for rescission. Kapag lumagpas yung 4 na taon na yan, wala na. Nagpas ka na. Barred ka na by statute of limitations. Or barred ka na by prescription. Or sometimes you are barred by latches. Okay? With respect to the absentee, ano yung absentee? Mga nawawala. Their whereabouts are unknown. Okay. Binenta nung representative. Anong gagawin niya? Anong gagawin ni absentee? Kung ang pinasok na kontrata ng kanyang principal nung kanyang representative ay rescissible. Pwede niyang ipa-rescind. Pero hanggang kailan siya pwede magpa-rescind? Once na nag-reappear siya, nalaman mo na kung saan siya nakatira, na-figure out mo na kung nasaan na itong tao na ito, you have 4 years from your reappearance. Kapag nawala na yung status mo bilang absentee, saka lang magbilang yung 4 na taon para ikaw ay manghingi ng rescission. Tapos na. That's the first defective contract, rescissible contract. Okay? Kung mapapansin ninyo, lahat ng nangyari ay puro agrabyado sa ibang tao. Kaya naman, yung kasunod ay voidable contracts na. Voidable contracts. Sa voidable contracts, again, na pag-usapan na natin to before, merong problema dun sa pagbibigay ng consent. May problema sa pagbibigay ng consent. So the following contracts are voidable or annullable, even though there may have been no damage to the contracting party. So hindi required ang damage. Unlike dun sa previous, dapat may damage. Sa rescissible, dapat may damage. Kapag walang damage, ay hindi pwede magpa-rescission. Dito sa 1390, hindi required ang damage. Voidable. Voidable contracts are valid contracts. Nakalagay sa baba. These contracts are binding. They are valid and binding unless they are annulled by a proper action in court. So hindi yung parties ang mag-decide kung annulled na ba yung contract o hindi. You have to go to court, and the court will have to hear both parties, and the court will render its decision whether or not the contract is indeed voidable, and the corresponding decision kung i-annul ba yan o hindi. Bakit voidable ang contracts? Number 1, because one of the parties is incapable of giving consent to the contract. Malay mong siya ay minor, siya ay insane, siya ay deaf-mute who do not know how to write. Yan. Hindi siya makapagbigay ng tamang consent. Or, even if they are allowed to give their consent, those where the consent is vitiated by VIMPO, violence, intimidation, mistake, fraud, and undue influence. Alam na natin lahat ng yan, pag-aralan na natin yan. These contracts are binding unless they are annulled by the court, and they are susceptible of ratification. Ratification, again, is not the first time that we will hear about ratification. When we say ratification, ano ang keyword natin dito? Cleanse. Cleansing of the defect. So, ibig sabihin, ang mga voidable contracts daw ay maaaring i-ratify. So, kahit na ito ay may problema doon sa pagbibigay ng consent later on, if they figure out na okay naman pala yung yung kahit na at that time na nagbigay ako, defective ang kontrata na figure out ko later on na okay lang din naman pala siya, so wag mo na siyang ipa-annul. Dalawa yung choice mo. If you think na talagang naagrabyado ka doon, again, hindi kailangan ng damage. But if you think gusto mong ipa-annul, then wag mo siyang ipa-ratify. Kasi once na i-ratify mo siya, it is cleansed of its defect and you are no longer allowed to ask for its annulment. So you choose wisely. May dalawa ka namang remedyo. So choose wisely between your two remedies. Either you ask for his annulment or you ask for his ratification. The action for annulment shall be brought within 4 years. So meron agad siyang, anong tawag natin dito pag nagbibilang? Meron siyang prescription. Yan. Nagpe-prescribe siya. So just like, just like rescission of rescissible contracts, 4 na taon din ang karapatan mo to ask for annulment. Huwag niyong i-mix-mix yung mga remedy, ha. Kapag rescissible ang contract, ang remedyo mo ay ipa-rescind. Ask for its rescission. Kapag voidable ang contract, hindi mo siya ipapa-rescind kasi hindi mo siya rescissible. Anong gagawin mo? You ask for its annulment. Annulment. Kailan ka pwede mag-file ng action for annulment? Within 4 years from. Now, in case of intimidation, violence, undue influence, kapag nawala na itong mga to. So kapag nawala na yung intimidation, nawala na yung violence, nawala na yung undue influence, counting na ng 4 years. Nawala na, ibig sabihin pwede ka nang kumilos. Nawala na nagbabawal sa'yo. Tumakbo ka na agad sa korte, teka lang, pinipirma niya ako habang may nakatutok na baril sa akin. Huwag kang magpatagal-tagal na lumipat ang 4 na taon bago mo gawin yun. Tataka yung korte, teka lang, 10 taon na lumipas, saka mo palang irereklamo. Dapat agad-agad. Yun yung gusto ng korte. Agaran. In case of mistake or fraud, from the time of its discovery, natapos na ang lahat, saka mo lang nalaman, ay mali pala ako. Nagkamali pala ako ng intindi or niloko pala niya ako. Kapag ganon, if based on mistake or fraud, the 4-year period will be counted from the discovery of what? The discovery of the mistake or the discovery of the fraud. Kasi kung alam mo may mistake ka na tapos wala ka pa rin ginagawang remedyo, hindi ka pumupunta sa court for its annulment, then again, sabihin ng court, you are barred by prescription. Meron kang 4 na taon under Article 1391, hindi mo inavail. Naintindihan ko mukhang talagang nalamangan ka kasi may fraud or may mistake. Pero nalaman mong may fraud or mistake, wala kang ginawa. Pinalagpas mo ang 4 na taon. Wala na akong magagawa dyan, sabi ng korte. I can no longer do anything about it. You are already barred by prescription. And when the action refers to contracts entered into by minors or their incapacitated or other incapacitated persons from the time the guardianship ceases. So kapag minority ang naging ground mo for the annulment of the contract, then you have 4 years from them reaching the age of majority. So kung ako yung minor dun sa voidable contract, pag na dumating na pagiging 18 ko, then I have from my 18th birthday 4 years from my 18th birthday to file an action in court for the annulment of the contract. Okay? So 4 years is important, not only in voidable contracts but also in rescissible contracts. Ratification extinguishes the action to annul a voidable contract. This is self-explanatory. Kasi once you ratify the contract, it is already, ano ulit? It is already cleansed of its defect. Nawawala yung mga defect. At kung nawala na yung defect, there's no more basis for you to ask for the annulment of the contract. Sabi ko nga, you choose between ratification or annulment. Para sa naman yung legal. Sir, ang mga rescissible contracts ba ay nira-ratify? Hindi. Kasi valid sila eh. There's no need for it to be ratified. Ito, may defect. So, kung gusto mo i-ratify yung defect, okay lang. It's up to you. Gusto mo siyang i-ratify. But once i-ratify mo siya, wala kang karapatan to ask for its annulment. The remedies are exclusive of each other. 1393, ratification may be effective expressly or tacitly. Alam na natin lahat to, di ba? Pag ratification, yung pagpapapayag mo, yung pag-iisip mo na okay lang to. Pero mong sabihin directly, okay lang to. Nira-ratify ko to. Sige na, tuloy lang natin, etc. etc. Yun in-express mo talaga or tacitly. Nalaman mo na nanahimik ka lang. Nakita mo na sisipol-sipol ka pa. Pag ganun, pumapayag ka. Impliedly, pumapayag ka. It is understood that there is tacit ratification or implied ratification if, with the knowledge of the reason which would render the contract voidable, and such reason having ceased, the person has the right, who has the right to invoke it, executes an act which necessarily implies an intention to waive his right. So, gagawa na lang ako example, ang haba ng binanggit niya. Si X ay minor. Si Y ito. Nagkaroon ng contract of sale between them. Si X ay magbabayad ng 200,000. Si Y ay magde-deliver ng bike. Huwag natin ipasok yung minority. Para mapilit, no? Para mapilit si X na magbayad ng 200,000 kay Y para dun sa bike. Tinakot ni Y si X, tinutukan niya ng baril. Pirma na. Pirma na. Contract of sale, pirma na. Okay. Nakatutok ng baril. Sige na po, pipirma na. Nanginig siyang ano. Sa status ng kontrata, voidable. Because the consent was obtained by intimidation. Vitiated ang consent. So ano mangyayari? Ang X can ask for the annulment. Yun yung karapatan niya. Ask for the annulment. Pero, nung nawala na, no? Yung nawala na, yung intimidation, X comes to Y and ask for the bike. Sabi ni X kay Y, di ba nagbentahan tayo? Yung nakatutok yung baril sa akin. Nasaan na yung bike? Nahanap niya yung bike. X could have asked for the annulment of the contract. Alam niya na annulable yung contract kasi siya nga yung biktima dito. Sa kanya nakatutok yung baril. So voidable yung contract insofar as X is concerned. Pero notwithstanding the fact na alam ni X na voidable yung contract, X is asking the bike from Y. So ano nangyayari dito? Nagkakaroon ng tacit ratification or implied ratification. Yan yung 1393. 1394, ratification may be effected by the guardian of the incapacitated person. The guardian of the incapacitated person. So you have the guardian, you have incapacitated person. So incapacitated person ay nagbenta kay X. They entered into a contract, whatever it is. Kung si I ay incapacitated, si X ay hindi, anong status ng kontrata? Voidable. Diba? Voidable. Kapag yung isa ay incapacitated, voidable ang kontrata. So hindi mo kailangang hintayin yung pagiging of age ni incapacitated person. Si G mismo, who is the guardian of I, can ratify the contract. G can ratify it whether expressly or impliedly. Pwede. Yun yung sabi ng 1394. The guardian can ratify the contract on and on behalf of the incapacitated person. That is the express mention of Article 1394. 1395, ratification does not require the conformity of the contracting parties who has no right to bring the action for annulment. So kung si X at saka si Y, si Y tinutukan niya ng baril si X para pumasok dun sa kontrata. Whatever it is, kung ano man yung kontrata na yan. Sabi ni Y kay X, pirma. Okay. Napilitan si X ngayon magpirma. So between X and Y, sino ang may right for annulment? Who can ask for the annulment of the contract? Siyempre yung biktima. Sino bang biktima dito? Si X. X being the victim of the intimidation, X has the right to ask for the annulment of the contract. Si Y ba may karapatan na mag-ask for the annulment? Sabihin niya, tinakot ko si X eh. So voidable ito, I will ask for the annulment. Hindi pwede. Diba? You are the guilty person eh. So you have no right. You are not granted any right under the law. Ikaw yung nag-cause na kung bakit avoidable kasi ikaw magpapa-annul. Hindi pwede. So X can bring the action for annulment. Y cannot bring the action for annulment. Pero sabi nga natin, X is not required to ask for the annulment. X may what? Ratify it. Kung ayaw niyang mag-undergo ng annulment, X can ratify the contract. And sabi ng 1395, the ratification made by X does not require the conformity, meaning the consent or the agreement. Hindi niya kailangan tanungin si Y. Sabi ni X kay Y, alam ko, naalala ko, tinutukan mo ko ng baril, kaya ako pumirma dyan. Sabi ni X, pero okay lang yon. Nira-ratify ko na yon kahit na ako ay biktima ng iyong intimidation. Hindi kailangan tanungin ni X si Y na, okay lang ba sa iyo yun? Hindi kailangan. Si Y ngayon nag-cause ng ng annulment. Tapos tanungin mo kung okay lang sa kanyang i-ratify. So hindi required yung consent o yung conformity ng guilty person if the other person will ratify the contract. 1396, ratification cleanses the contract from all its defects from the moment it was constituted. So ito naman retroactive. Although sinabi ko na sa inyo paulit-ulit yung cleanses, yung effect niya ay simula. So for example, X, ito 2 years ago, ay tinakot ni Y, tinutukan ni Y para pumasok dun sa kontrata. Okay. So kung ira-ratify yan ni X today, yung effect ng ratification niya today will retroact 2 years ago. As if 2 years ago, valid na siya, walang defect na nangyari. Yan yung effect ng ratification. Babalik yung ratification at the moment it was constituted. 1397, the action for annulment of contract may be instituted by all who are thereby obliged principally or subsidiarily. However, persons who are capable cannot allege the incapacity of those with whom they contracted, nor can those who exerted intimidation, violence, or undue influence, or employed fraud, or caused a mistake, ask for the annulment. So ito, alam natin itong pangalawa sentence. Alam natin to. Kung ikaw yung nag-cause ng defect, or between the incapacitated and incapacitated, ikaw yung capacitated, wala kang karapatan na mag-ask for its annulment. You cannot do that. Pero sabi dun sa una, the action for the annulment of contracts may be instituted by all who are thereby obliged principally or subsidiarily. Okay, so for example, X is a minor. M is a minor. May utang siya kay Y. Guaranteed by G. Minor pala si M. Pwede bang i-invoke ni G minority ni M para ipa-annul yung contract? Yes. Normally, di ba, kung sino yung minor, kung sino yung biktima ng intimidation, violence, fraud, sila yung may karapatan to ask for the annulment. Pero, yung mga parties who are subsidiarily liable like G can raise the minority of M to ask for the annulment of the contract. Pwede sila. If they are interested in the satisfaction of the obligation, pwede sila. Pwede rin yung surety. Ay, minor to. I will ask for the annulment of the contract. Yun yung sinasabi ng 1397. Pero kung ikaw, yung nag-cause ng intimidation, violence, fraud, undue influence, or mistake, or between a capacitated and incapacitated, you are the capacitated person, you cannot ask for annulment. 1398. An obligation having been annulled, the contracting parties shall restore to each other the things which have been the subject matter of the contract with the fruits, the price with the interest, except in cases provided by law. So just like unenforceable contract, if you will ask for the annulment, kailangan magkaroon ng mutual restitution. Kailangan magkabalikan ng kung ano man ang natanggap ninyo under that voidable contract. So for example, ikaw yung minor. May bumili ng ng bisikleta mo. Minor ka. Voidable 'yon. Binigyan ka ng pera naman. Binigyan ka ng pera, pinabili mo lahat ng pagkain. Then dumating yung age of majority mo, sabi mo, ay, voidable yun ah. I will ask for the annulment. Okay. Sabihin ng court, sige, i-annul natin tong contract. Can you return? Kaya mo bang ibalik yung perang natanggap mo doon? Kung hindi mo kaya, then the court will not grant the prayer or your action or your complaint for the annulment of the contract. Even if it is voidable, Article 1398 requires you to return what you have received under that contract. Just like unenforceable, just like rescissible contract, kapag grinant ang annulment, there must be mutual restitution. In obligations to render service, the value thereof shall be the basis of the damages. So, syempre, wala nang balikan pag serbisyo. Ano pang ibabalik mo, na-render mo na. Alam, bawiin mo yung serbisyo. Yan. So, kapag serbisyo ang subject matter, then it will be converted to a monetary recovery of monetary damages. 1399, when the defect of the contract consists in the incapacity of one of the parties, the incapacitated person is not obliged to make any restitution except insofar as he has been benefited by the thing or the price received by him. Ito yung binanggit ko kanina. So kanina, kung pinambili ng pagkain ni X yung pinagbentahan niya ng kanyang bisikleta nung siya ay minor, required siyang ibalik. Pero what if si X ay minor, binenta yung bike kay Y. So yung bike na kay Y na, si X ay nagbigay ng 5,000 pesos. Kung si X, again, kung ipambibili niya ng pagkain, nag-benefit siya doon sa perang natanggap niya o kaya tinago niya, for example. Kapag nag-ask siya for annulment, kailangan niyang ibalik yung pera. Kasi nag-benefit siya doon or tinago niya. Pero, kung si X, sinunog niya yung pera. Minor siya, natanggap niya yung 5,000, sinunog niya. Nainitan siya. So, kailangan niya ng apoy, siniliban niya yung pera. Nakaganon siya ngayon sa pera niya habang umaapoy-apoy yung pera. And then later on, he will ask for the annulment of the, kasi siya nga yung minor dito eh. He asked for the annulment of the contract. Required ba siyang magbalik? Hindi. Required lang siya magbalik if yung pera na tanggap niya ay nag-benefit siya or tinago niya yung pera na tanggap niya. 1400, whenever a person obliged by the decree of annulment to return the thing cannot do so, because it is lost through his fault, he shall return the fruits received and the value of the thing at the time of the loss with interest. So kapag hindi mo kaya, pag object yung pag property, yung required ka na ibalik, pero hindi mo na siya maibalik because of your fault, anong mangyayari? Lusot ka na ba? Hindi. Kailangan mong ibalik yung value ng thing, including the fruits, with interest. Yung value of the thing, including the fruits and interest. Pag hindi mo na siya kayang ibalik. Again, hindi mo na kaya yung mutual restitution, then, tas in order yung balikan, it will be converted into a monetary, recovery of monetary damages, value of the thing, and then the fruits with interest ang ibabalik mo. 1401, the action for annulment of contracts shall be extinguished when the thing, which is the object thereof, is lost through the fraud or the fault of the person who has the right to institute the proceedings. So kung baliktad, for example, X ay pinagbentahan si minor to, nasa kanya ngayon yung bike. Siya yung bumili ng bike. So yung pera na kay Y. Si Y ngayon yung may hawak nung 5,000. Sabi ni Y kay X, bili mo ng bike ko for 5,000. Eh, minor lang naman si X, binili niya. So nasa kanya ngayon yung bike, yung 5,000 na sa ibang tao. Because of the fault or fraud of X, the bike is lost. Again, between X and Y who has the right to institute the proceedings, X. But if, because of fraud or fault of X, the bike is lost, wala na siyang karapatan na mag-ask for annulment. The action for annulment of contract shall be extinguished. Hindi na i-honor ng batas yung karapatan mo na mag-ask for the annulment if the loss of the thing which you receive under that voidable contract is lost because of your fraud or fault. Second paragraph, if the right of action is based upon the incapacity of any one of the contracting parties, the loss of the thing shall not be an obstacle to the success of the action unless said loss took place through the fraud or fault of the plaintiff. Same lang naman to, no? Okay. 1402, as long as one of the contracting parties does not restore what in virtue of the decree of annulment he is bound to return, the other cannot be compelled. Pag sinabi ng korte magbalikan kayo, mutual restitution, balik-balik ninyo yung mga natanggap ninyo, hindi pwedeng persahin ng isa yung isa kung hindi siya ready. Kung hindi ka ready, hindi ka rin pwedeng manghingi ng, kung kanya ready ako, siya hindi siya ready. Hindi ako pwedeng pilitin na ibigay yung handa akong ibalik hanggat hindi siya handa na ibalik yung nakuha niya sa akin. So, dapat sabay kayo. Walang mauuna. Okay. That's it for voidable contracts. Next na yung unenforceable contracts, which will be covered by a separate video. Okay? See you on the other video. Next video.